truths and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause. This is a podcast covering the legal and criminal justice system here in Allen County, Indiana, northeastern Indiana, and the state of Indiana, all about Indiana. I'm Jamie Duffy, your host and a local journalist. To my left is Michael McAlexander. He is the Allen County Prosecutor, and thanks once again for being our legal expert. Today, we're really going to rely on him, I have a feeling. Also contributing is my right hand. She's still a mystery who she is, I know. We will let her get stronger before we discuss that. You will want to catch our episode from last week. We interviewed John McGauley, the court executive here in Allen County. We had a lot of fun on that one. He told us some of his memories and experiences. You can catch that on www.theprobablecause.com, and we would absolutely love it if you would listen to that. Also on Apple and Spotify and YouTube. Should mention all three of those. I also have a story that I wrote on my own, nothing to do with anybody else, on two gentlemen in Northeast Fort Wayne. They're master gardeners. They allowed a marijuana plant to grow in their backyard, very walled in, very lush garden. Anyway, the Indiana State Police marijuana eradication team did see that from a flyover. They were charged with a criminal misdemeanor. One of the fellas took the rap because he is supposedly the one that decided not to cut it down. It was a gift from nature, so to speak. So as I would say, there were consequences. Their public defender was Sean Arata. They loved him. And so anyway, I would urge you to go read that too. I think it's a very interesting story. And just remember that marijuana is still illegal in the state of Indiana. So before we get to the courts, something worth noting in our quest to open a law school in Indiana, in Allen County. First of all, in Indianapolis, which is the state's largest city, we are the second largest, something called the Legal Prep Charter Academy, which was founded in Chicago in 2012, will open its second charter school. It will be grades 6 through 12, and it's going to open next year. The existing prep charter school is in West Garfield Park, if anybody knows that area of Chicago. My mother grew up there, but I couldn't tell you where. And I also went to grad school there at Medill School of Journalism. I could not tell you where West Garfield Park is. The co-founder, Samuel Finkelstein, will open the school, and he will be its principal. But as I say, that's time-tested, and I think charter schools, when they do things like this, I think it's really cool and good for society. What do you think, Mike?
Well, I think it's very much the article I read on it said it's civics kind of background, and they'll have different emphasis for different grades. But yeah, at a time when we have a shortage of attorneys and a lot of interest in criminal justice.
We do.
I think it's important, and civics in general. There's just so much that people don't understand about how government operates. And a lot of it is just the fundamentals. So I think it sounds like a really nice way to go. I'm sure it will be kind of a college prep, a lot of literature as well, reading, writing.
Would hope that the humanities, how about Dostoevsky's Crime and Punishment? That's a very long book. Have you read it?
No, I have not.
I read it years ago. Years ago. It was a great book, let me tell you. I think if we do get Samuel Finkelstein to come here to Fort Wayne and open one of these, we should call it the McAlexander Legal Prep. How do you like that? Love it. Now, another thing that's very interesting is that there is a commission on Indiana's legal future, and it has a new proposal for an alternative exam for bar admission. Okay, it's called the alternative exam. I believe this was in Indiana Lawyer as well. if a student finishes first year law school, so you do have to get into law school to qualify, you take the multi-state performance test section of the bar exam that's focused just on Indiana law and agrees to work in a high need area like public defender or the DCS. They waive the bar exam that takes 2 days, but I guess maybe 1 day they would, close it down to maybe 1 day. It's hard to say. It did not say in the article as far as I know. Indiana is basically in desperate need of attorneys. According to this article in the Indiana Lawyer, Indiana ranks 43rd out of 50 states for the number of lawyers available, basically 2.26 attorneys per 1,000 people, which kind of sounds like a lot, but I guess it isn't. And in this case, the quote from Shakespeare, "First, let's kill all the lawyers," does not apply. I did do some background on that too, but we might not have enough time because we're going to talk about double jeopardy. What's more interesting, I was going to bring this up with Mike, is the retention of lawyers who go to these 3 law schools that we have in Indiana. So the McKinney School of Law in Indianapolis, 95% of its graduates stay in Indiana. That's super. Mm-hmm. That's really great, okay? But if you go to Bloomington, it's only 58%, so just a little over half. Then if you go up north or northwest or whatever it is to South Bend to Notre Dame, it's only 18%, which is what we were talking about last week. They come from elsewhere. It's sort of a mecca, has an excellent reputation, as we all know, but they just don't stay here. Only 18%, not even a quarter of them stay here. So I guess it just underscores why we need more law schools. I did write to this guy to see if, the professor who was quoted in the article is a professor at the McKinney School, which is Mike's alumnus or alumni. And so I asked him, hey, would you consider opening up a law school in Fort Wayne? I'm not going to give up on this, I'm telling you. So anyway, this week in courts, what have we got, Mike?
We actually have a murder case going this week. Woman was killed at the Kroger in Waynedale shortly before Christmas in 2023. So they picked a jury this morning, it's my understanding, and would start with opening statements and their first witnesses this afternoon.
So who do we have on the prosecution team?
Tessa Helge and Tom Shaley.
And those are the top 2 prosecutors right under Mike. Tom Shaley is the chief deputy and Tessa Helge is the chief counsel. So, and then for defense, who have we got?
Robert Scremin.
Right, and they all met with each other last week at the murder trial.
And I think they may be up again next week, or at least Tessa and Robert.
That's exhausting. Last week, we had a murder trial. It was Terrence Sanders. He's all of like 2021, happened 2 years ago, just before the stabbing. As I recall, it was a stabbing at the Waynedale Kroger. Mm-hmm. He's going to likely spend the rest of his life in prison. He was convicted of murder, of attempted murder, of battery, and of course, of criminal gang activity. And on top of that, he had the gun enhancement, which can add 20 years. So I believe he's looking at over 100 years for this. I know counselors out there like Angelo Monte with Alive, Roderick Parker with Big Hearts, 10 Point Coalition. They take these failures personally, but they're fighting a culture that is overwhelming, and I can only say we feel horrible for both families, literally. He's the first of 4 who's going to face these same charges because there were 4 of them in the car, borrowed from a female friend. I wish the female friends would stop lending these guys cars. I mean, she kind of knew, according to this excellent probable cause written by lead homicide detective Aaron Johnson, she kind of knew where they were going. And And then there was another woman, or another girl, I should say, in particular, who was feeding them back information, was Avian Parker there, who's the victim, and his brother. And she was relaying this information in text messages. Now, neither one of them was charged, but they were definitely involved in it, right? And so it was, and also it was between two feuding gangs. It was the Big Swen gang and the Big Money gang. They've been around for a while. They keep churning through and getting younger members, as far as my research tells me. So once again, insurmountable evidence, and it was an interesting trial. Do you want to say anything about that one, Mike?
It hasn't been sentenced, so I don't want to comment on the facts of the case, and with other co-defendants awaiting trial, don't really want to say anything other than, and this is kind of a message to the kids, the parents.
Right.
You're turning your life into a tragedy.
You are.
I mean, let's get real. If you're convicted of murder in Indiana with the 75% of the sentence that you serve, along with the gun enhancement, your range there is 45 to 65 years on murder.
And they're arresting all of them.
Oh yeah.
Yeah, I mean,
It's not like it used to be where 50% of them walk. You
Yeah.
don't walk anymore in Allen County.
Well, when you're saying walk, you're just meaning that the homicide team is extremely effective these days.
Exactly. They're kicking ass and taking names.
and you just hope that
One way
somebody,
to put it.
well, that somebody gets through to these frequently kids, that they're going to trade their life, basically, because they're going to spend the rest of their life in prison.
Right.
And is it really worth it over some of this stuff? And
That's the message these OGs need to be getting out in the streets. Like, the old rules don't apply. You will go to prison for the rest of your
Well,
life.
but the OGs are getting out there, and Roderick's getting out there, and Angelo has a whole program in literally every one of the schools in Fort Wayne now. I mean, they're doing and I will say this about Terrence Sanders. He did have a family. I saw them in the courtroom. He had a mother and a father. They showed up every day I was in court. This is not a fatherless child like we hear about all the time. He got direction, and I know personally from what some of my sources have told me, the parents are sick about it. They're just heartsick about it. So you're right. We got to do something. Okay.
That's a great message, Mike. That's a great message for the prosecutor to be putting out there. Like, you will go to prison. We will win, and you will go to prison.
I mean, you look at, as you said, the solve rate is nearly 100% this year and last year. Mm-hmm. We've come a long way in the last 5-6 years.
Oh, yeah.
And you're not going to get away with it necessarily. And the punishment is living in a prison cell the rest of your life. So if there are girlfriends...
And just the shooter. If you're with the shooter...
Yeah.
And you have anything to do with it, you're going down too.
That's right. They're all acting in concert.
Yes.
Right.
There were 2 guns used. The victims also turned around and shot back because the girl who lent the car, she got bullet holes in her car, and she freaked out when she saw them. So it's just a mess all around. So maybe we should really send a message out to these young women.
Yeah.
Hey,
Well,
you know what? Go find a decent boyfriend. Sorry.
Well, I mean, I think you've always got that classic question that parents ask their kids as they're going out at night, what you going to do? Oh, just hang out.
Right.
Parents need to ask a few more questions and cover what their kids are up to. And maybe some of that, nobody wants their kid to go to prison for the rest of their life. Nobody wants their kid dead. But so much of this is happening. And if these young ladies, as you say, that frequently let their boyfriends borrow the car, do you want him to go to prison? Do you want him to be dead? Then ask him, what's he doing? Is this worth it?
Oh, and the other one, he said, yeah, we're going to bring your car back. Terrence Sanders was quoted as saying in the probable cause, we're going to bring your car back, but we got to drop off a couple of guns first.
Yeah.
You know, red flag. Of course, that was after the fact.
Yeah, so I don't know how we get that message across that just don't do this stupid stuff for such little gain. Whether it's a fight over marijuana or other drugs or gym shoes or girls, is it worth spending the rest of your life in prison? And somehow we have to get that message out to young men. I mean, any of us who have raised kids know that younger people are more impulsive. They'll do something on the spur of the moment without thinking of the consequences. But this is stuff that, for the adults, for the people who love them, make them stop and think as best you can.
Thinking right here, we should have the traveling podcast show. We should be taking this to the high schools.
Oh.
Come on, Mike, let's go on the road.
We go to Florida.
Well, I'm just thinking, in Allen County first, and then we'll go, if you need us there, we'll be there. So we could even go down to Indy because they have a problem down there. So on to double jeopardy, which is a legal principle guaranteed by the Fifth Amendment of the U.S. Constitution. This is what it does. It prohibits a person from being prosecuted twice for the same crime after a trial. This constitutional protection is meant to shield individuals from being subjected to the hazards of repeated trials, potential conviction, and punishment for the same alleged offense. So I'm going to go over the first one. Same offense. The core of the double jeopardy rule, which I've never heard of a double jeopardy rule, is whether the second prosecution is for the same offense as the first. So it looks like you could get in some trouble here.
Yeah. I think we've mentioned this in passing before, probably talking about charging. And when you make a charge, and as right hand knows, there are times that we're reluctant to charge because we don't feel like we have enough good evidence to prove our case beyond a reasonable doubt. Well, that's very frustrating to hear for a family when they say, but somebody came forward and said that it happened or that they saw it. And you're going, yeah, but that person may not be the most reliable person in the world.
Could it be hearsay too? I mean,
well, it depends what they saw or heard. But if we don't feel that person is a strong enough witness, or there isn't corroboration of their testimony, we might say, well, we want to hold off till see if we can develop some additional evidence, either corroborating that statement or other stuff that would point to the guilt of the defendant. But people are anxious. They want something done now. Well,
and that's pressure that,
we had a case like this that was a double homicide and an attempted murder. And there was a key witness, and it was taken to trial. Well, this guy gave several different stories about what happened. So it went to trial, and it was a not guilty.
Because he changed his story too often.
The witness did. Well, that puts us then, if anything comes up later, he could walk into my office after he's found not guilty at trial and admit that he did it, and I couldn't prosecute him. This never happened to me, but in theory, that's why we're cautious when we get into double jeopardy, that if we lose a case, we cannot turn around and try them again. Mm-hmm. And now this should not be confused with situations where there's a mistrial. And the most common mistrial is due to a hung jury where a jury can't make a unanimous decision. Then we do have the ability to try the case again. But If you get a not guilty, then you cannot try them again on those charges.
Right, and it makes sense when you start thinking about it. If you're found not guilty, that's it. You can't be tried again. But if it's a mistrial, it's just hanging out there. So you get to try it again. Here's another point. For the protection to apply, the double jeopardy rule, jeopardy must have attached in the first trial. In a jury trial, this occurs when the jury is sworn in. In a bench trial without a jury, it happens when the first witness is sworn in. So the wording here kind of threw me off. For the protection to apply, jeopardy must have attached in the first trial.
Basically means the trial must have started, if you want to think of it that way. And we generally, as you just said, we consider that started with a jury trial. There's actually 2 oaths that jurors take. When they first come in, they're taking an oath to be truthful in the jury selection process. Then once they get the 12 people in the jury and any alternates, they will swear in the entire jury to be fair and impartial in hearing of the case. So it's at that second point is when jeopardy attaches.
So when I've never been in a jury here in Allen County, and I was never called to be on one. I was called to be one in New Jersey, and I thought they were going to choose me. I was so glad when they didn't, because I actually knew of the guy. He was a doctor. So do they explain that thoroughly when they're sworn in? Hey, that.
No. It looks like more of a official ceremony to welcome the juror. I mean, to the jurors that are taking that, I'm sure they listen to the words and they understand this is starting, but to them, I don't know that it makes a big difference because they're there to tell the truth during the jury selection process. But they really, their role after that is to listen to the evidence, stay awake.
Stay awake.
And in Indiana, they are allowed to ask questions, submit questions in writing after each witness.
It's funny you say stay awake, because I have looked over at the juries and I'm thinking, that guy's looking down, I just I can remember telling one of the defense attorneys, I'm a little bit worried that guy was sleeping. All right, so civil versus criminal. The clause generally applies to criminal proceedings, but it can extend to civil sanctions if they are considered punitive in nature. And I believe the best example of that is O.J. Simpson. Am I correct? Should I read it again?
Well, I think this is where it can get a little confusing at times.
Right. I knew it was complicated.
Where you've seen situations like O.J. was acquitted of his criminal case, but then there was a civil lawsuit against him for wrongful death. So,
and he was convicted in that, or whatever.
He was found liable for the deaths of the 2 people. A civil proceeding is generally excluded from the double jeopardy. But I can tell you where it also can be confusing is you'll see I think this has happened in like the George Floyd case, but frequently if prosecution is entered against a police officer for a police action shooting, or in the George Floyd case, they charged 4 police officers with causing his death or being responsible.
Yeah, at least 3.
Yeah.
I remember the 2 guys who were, one of them was actually saying, wait a minute, don't you think you've gone too far? And he was still charged.
And in that situation, I believe the federal government, the state court, that trial got most of the original publicity, a murder trial in the state court. But there also was a federal civil rights violation of civil rights suit brought that created a criminal sentence as well. This is where it can be confusing to the public and to people in general, myself included, that I understand it's different charges, but it was the same behavior that resulted in the conviction.
It was the same crime.
Well, Murder is knowingly or intentionally killing another person. Violating their civil rights is something different.
Oh, wait a minute. I was thinking about O.J. Simpson. Forget it. No, yeah.
But
that's completely
But when
Sorry.
but the same actions then were used.
Right.
It was the same incident that they were charged with. Generally, in state court, if we have multiple potential charges, so let's say I break into your house, pistol whip you, and steal your television.
That kind of
run
sounds
away.
like one that I covered a 3 weeks ago.
Well, if the
Royal.
if the prosecutor doesn't charge all of those, that would be like a burglary, a robbery, a battery,
Right.
but it's all part of the same incident. If I don't charge that and I get a not guilty, let's say I don't charge the burglary, so I just do the robbery and the battery and get a conviction or get a not guilty, say.
Okay. Not guilty.
I can't then come back and file the burglary charge. Oh, I missed him on the 2, so I'll get him on this. You've got to put everything in the incident together, which is confusing to people sometimes. We're very cautious. Say when you have a traffic incident, say a fatal crash, and the officer writes up, failing to follow a traffic signal, which caused the crash. Well, they may also have been drunk, may also have done other things. So if you're waiting, say, to get your tox report back and all of that stuff to file the OWI, you don't want to file the infractions or any misdemeanor offenses at the same time, because they're all put together in one incident. If you go ahead and get a conviction on any part of it, it would preclude you from additional prosecution.
And that's sometimes, that's a really good point. He said tox report, which he means, the alcohol report, or if they had drugs in their system, they have to wait for the toxicology report. But sometimes people will say, why do investigations take so long? Well, that's one of the really good reasons right there. Toxicology report can take months. I don't know if they've shortened it.
It depends. I mean, anytime that you're sending something out to be tested. The other thing, like for blood test or after an autopsy, if you need to have toxicology look at that. If you're sending items out to the lab for DNA, it's not like it is on TV where you send it out to the lab and you get the result 15 minutes later.
Right. Just in time for the commercial. Or no, just after the commercial.
The other thing that frequently takes some time is with social media. There's a lot of times when we are looking to get reports from Facebook or telephone carriers about the history of calls and all of that, or to have a phone looked at by digital forensics. So there's a lot of scientific stuff that has to be done now that takes time on that.
Yeah, more and more. I mean, it's like the one that I covered last week, I would say the telephone mapping, the cell phone mapping was crucial because it placed him right there, turned his phone off, then he turned it back on, but it put him right there where it happened at Villa Capri Apartments. So here's another one. If a conviction is overturned on appeal, a retrial is not barred by double jeopardy because the original judgment was invalidated. Now that one, I think, sounds unfair to me. Like the appeals court says, yeah, we're going to overturn this. And then all of a sudden the guy has to come back for a trial, second trial.
You think it's unfair to who?
The defendant. I mean, he's already, okay, he was found guilty.
Right.
But then an appeals court, a higher court, overturns it. So that one, in my opinion, should stand.
Which should stand the
appeals court.
Well, it gets into a distinction between an error that can be made, and that may very well depend on what the error was and who made it. I think you'd look at it a little differently if it got overturned because the defendant's defense counsel was ineffective. How is that fair to the victim if the defendant has a bad attorney?
But how would he be ineffective? What would be like? What would happen? Because it seems like if he'd be ineffective, then why was he found guilty if he had a bad defense attorney?
Well, that's why he was found guilty. That's one of the most common reasons on post-conviction relief that cases are reversed due to the ineffective assistance of counsel. And how is that fair to the victims? If that was the case, every defense lawyer would go in and do nothing.
But I mean, what would they do to be ineffective, I guess is what I'm wondering.
Not object to certain evidence coming in that should not have been admitted.
Oh.
Not.
But see, that would have been on the prosecution then, to introduce evidence that shouldn't have been admitted.
Well,
right?
There's a lot of still after,
I know you're a prosecutor.
After 240 years of jurisprudence in the United States, we still keep the appellate courts busy because there's a lot of questions and they become very fact sensitive about the admission of evidence into trials. Sometimes you think you're doing the right thing and it turns out you're not. And the court makes a distinction. If the prosecutor intentionally does something, but we had a mistrial. What did they? I forget what they referenced a witness, not I think it was a state's witness, but not a police officer, but referenced that the defendant had previously been in prison. And
that was just recently, yeah.
And that caused a mistrial of that case, not ineffective assistance of counsel. But if it had gone through, it's possible that an appellate court might have said, due to no one's fault that way, the defense attorney should have objected. And
well, bad for him if he didn't. But didn't that happen in the Karen Reed case? Wasn't there a mistrial the first go round?
Well, there was a hung jury.
It was a hung jury, but I felt like they were trying to introduce evidence and the judge tossed it out. It was particularly important when they said that she showed up at the police station and they were trying to say that, maybe I'm not getting this right, when her boyfriend was killed, that there had been some of her tail light that was left around the body, but then they said it looked placed. And I think it was the prosecution was trying to say that she did hit him. I'm just sort of remembering something like that. And I know that Brock here was following that. There was something fishy there going on.
Kind of a weird case.
It was, but it was a mistrial, and there was some evidence that was thrown out, but it was a mistrial, so it wasn't overturned by the appellate court. I do like to read some of those too if I get time in the Indiana Lawyer, which is a great source for everybody to read. You do have to subscribe, but it's good. So now we're going to federal versus state.
Which I kind of was talking about, but go ahead and...
Oh, okay. It's the dual sovereignty doctrine that allows for a person to be tried for the same conduct by both the state and federal governments, as they are considered separate sovereign entities. However, if a person is tried federally, this is the important point, they cannot be tried federally again for the same crime.
Yeah, double jeopardy applies in both jurisdictions, both the state and the federal. But it is confusing to people how the same conduct can be punished in state and federal. I believe, however, that their sentences are usually run concurrently when they have those situations.
Okay, we do need to explain that too. consecutively and concurrently?
Consecutively means that if you get, let's say you get charged with burglary and robbery, and you get 10 years for the burglary and 10 years for the robbery. If the sentence is served consecutively, you serve the burglary 10 years, then you serve the robbery 10 years. If they are concurrently, you serve them at the same time. So that can make a big difference on how much time you spend in jail. And there are all sorts of rules about consecutive and concurrent that get really deep in the weeds.
Right, because I can see a lot of these guys who end up going to prison, they become, they get all the cases and they do their research and they, like you said one time, they don't really have that much else to do, which I think we should give people things to do in prison. That's just me, though. But what could they try and, like, if they're serving them consecutively, maybe they could try and get an appeal on one of them and shorten their sentence.
Yeah, they'll try anything. I mean, to figure out a way to shorten their sentence.
Yeah, I don't blame them.
But the federal state thing is confusing to people, and I think to defendants as well, because it seems as though you're getting punished for the same behavior twice, which is the fundamental foundation of double jeopardy.
Right. Well, but consecutively and concurrently.
And I should also say,
reporters who get it wrong.
And I should say also that at the local level, when we talk about state and federal, we usually work pretty close together on gun cases, drug cases, and we will, who can get the most bang for the buck kind of thing. So if the feds are interested in taking a case and they can get a better sentence, then
is that why they take them? Is that why they get waived up?
Well, it's not really waived. It's two separate paths.
Right, because I see the gun cases. I feel like the Northern District of Indiana, it's primarily drug and gun cases.
I think that's definitely a large part of their jurisdiction.
I'm waiting for some environmental, some, tax fraud. I'm waiting for some, securities related. But when I see the press releases come out, I don't see that. It's always drugs and guns.
Well, you can take it up with the next U.S. Attorney for the Northern District of Indiana.
Oh, who's that going to be?
Adam Mildred.
Really?
Yeah.
He's going to be he was definitely selected.
Well, he was nominated.
Wait a minute. What is?
You didn't know that Adam Mildred was I didn't realize he was going to be. Don't they have several of them, and then there would be the lead one? He's going to be.
I thought what's her name?
Holly Brady.
No, that's a judge. He's going to be a judge?
No, he's going to. Okay. Indiana has
Explain it.
The Northern District
Please.
And the Southern District.
Yes.
Adam has been nominated by the president to be the U.S. Attorney for the Northern District of Indiana. That requires Senate consent.
Wow.
U.S. Senate consent.
So he was nominated, I think officially around the end of June.
Yeah, it wasn't that long ago.
And
congrats to him.
So he is the first one from Fort Wayne, I believe, since the mid-1970s when John Wilkes was the U.S. Attorney for the Northern District.
Well, kudos, but I mean, he hasn't gotten his U.S. Senate confirmation yet.
No.
I wonder when that's coming. I just saw him in court last week.
The process, trying to explain how the Senate works. They've got this budget issue. They're kind of fighting over some appointments. I know in the U.S. Attorney for New Jersey, and I think the U.S. attorney for one of the districts in New York and the one in Los Angeles are all in controversy over they were appointed as interim, and there's rules about how long you can be interim without being confirmed. So there's a battle going on about the president's appointments for the U.S. attorneys and the federal judgeships.
Right. I did know about the one in New Jersey.
But
I was aware of that one.
But we're proud of Adam. As I said, this is the first time in almost 50 years, I think, since.
Right. Well, when you first said it, I thought, oh, he already has been appointed. I knew he was up for the job. But, I mean, I guess there's no controversy about him, like the New Jersey, L.A., New York, SDS at the
No, I think
SDNY.
it's just the process takes time.
Right. So we'll be looking for that one. Maybe we should get him on here, and he can talk about what exactly that's going to be, and we'll follow him. So back to Double Jeopardy. There was one in Quora that I thought was interesting. It says that Double Jeopardy protects a person from being prosecuted a second time for the same crime if he said he, but it could be or she, was acquitted the first time. We've already established that. But he said, believe it or not, Double Jeopardy was not uncommon in the British Empire in the late 18th century. So we're talking about the end of the 1700s. The British government did it to bankrupt certain defendants until it could put them in prison. And what I think that was when all those companies were formed, the trading companies back in the late 1700s. And so wonderful that the British government was not only beating up on the Scottish and the Irish and whoever else was around, but they were bankrupting certain defendants until it could put them into prison. The founding fathers found the practice abhorrent and explicitly abolished it in the U.S. Constitution in 1788. So here we go. Thank you to our founding fathers. Appreciate it. So to illustrate this, there is a famous murder case retold in the New York Times bestseller, Midnight in the Garden of Good and Evil by John Berendt. Now, I read that so long ago. All I can remember is it had voodoo in it. Am I right? There was some voodoo in it. Here's the story. And I kind of can't believe this happened because it was the 80s when this happened. But it was South Carolina. Okay, so Jim Williams, an antiques dealer and historic preservationist in Savannah, Georgia, was prosecuted 4 times for the 1981 murder of his employee, Danny Hansford. Williams always admitted shooting Hansford, but claimed self-defense. So Williams was convicted in the first and second trials, but the Georgia Supreme Court overturned the verdict each time on technicalities. We know there was a heated argument, this is the Quora writer writing, and that both men had loaded pistols, but Hansford's pistol apparently jammed. The third trial ended in a hung jury mistrial because one juror steadfastly voted not guilty. Williams was finally acquitted in the 4th trial. So that's 4 trials in the 1980s. And Double Jeopardy was definitely supposed to be in play. Such retrials are very rare because they are expensive. District attorneys, in this case it was a district attorney, not a prosecutor, will usually think long and hard before going to trial, even twice over the same crime. Comments?
I had an experience somewhat like that.
Really?
Mm-hmm.
Were you in a pistol fight with somebody?
No, the legal side of it.
Right.
I was special prosecutor in a case from St. Joe County, South Bend. And it was the murder of 3 people in an Osco drugstore.
You know what drugstore?
Osco drugstore.
Osco. Long since gone, I guess.
They've been merged with some others. Mm-hmm. This case got a lot of attention. It was 1990, and we didn't get the case till 2000, 2001. And it had a lot of interesting parts to it. It was something of a whodunit with an alibi defense, but with some other intriguing items of how the person who got into the store early on a Saturday morning and opened the safe and took money, and motivation behind that. A note was left in the pocket or on the floor by one of the victims. So it had a bloody note. It had fingerprints that were found that were argued about. They were the defendant's fingerprints, but on a crash bar in the loading dock of the store. He'd been a former manager of the store, but he had not been in the store for 6 months. So you got into how long can a print last on a door. He had an alibi of being in Indianapolis. That his ex-wife, who wasn't particularly friendly to him, but upheld his alibi,
stood up for him.
Yeah. So
do you think
there
he
were
was
rules
not telling
about
the truth?
I don't know that I'd go that far.
Okay.
But anyways, back to the legal part of it. We tried him, I think, in June of 2001, the first time. This was a real road show because Tim McCauley and I don't know if Tim died several years ago, but he and I were the lawyers on it.
So he was with the prosecution?
Yes, he was with a lawyer with our office.
And then didn't he become the city attorney?
He was the city attorney before,
Okay.
and then came over here for a while. But we also had an attorney, the former elected prosecutor from Brown County, who had been hired by St. Joe County to kind of reopen this. But then he was alleged to be conflicted out when we were appointed special prosecutors.
Oh, wow.
So he became more of our investigator, Mike Duckett. So we had that, and the defense attorneys were from Indianapolis.
Oh, boy.
And they
You don't want to mess with defense attorneys from Indy.
So they had asked before we got involved, I think, or it was right as we were getting into it, about a change of venue, because this was a very high-profile case in South Bend. And we took it to Newcastle, Indiana, Henry County. So it was interesting to do a case on the road like that, staying at the Steve Alford All-American Inn, if you've ever been through Newcastle.
Is it still
Has a
there?
big tennis shoe out in front.
Oh, that.
I've been there for a few years.
Classy.
But anyways, we tried the case, and it was a 2-week trial. The jury deliberated over 2 days for about 13 hours and could not come to a verdict. So we ended up trying it again about a year later. And in that one, we picked a jury in Delaware County and bussed them down one county to Henry County to try the case there. That jury came back with a guilty verdict.
So you prevailed.
And then it went up on appeal.
Oh. Uh-oh. By the way, here's the tennis shoe.
Yeah, okay. And the court found reversed on 2 counts. I believe it was a pretty tight in the Court of Appeals, 2-1, and the Supreme Court was like 3-2 in upholding the appeal. So it was close questions, and it regarded a supposed other person as a defendant who testified more like a deposition, but outside the presence of the jury on like a Friday afternoon. And then the following Tuesday, when the defense called him as a witness, when he got to the appropriate part, he said he couldn't say the name. So we asked that his testimony be stricken. It was. The defense tried to use the testimony that he had given a few days earlier, that he did name his co-participant. We objected to that, and the Court of Appeals said, no, that should have come in.
Oh.
And
so they upheld the guilty.
no, they overruled it because the judge had granted our motion to strike all of his testimony and not allow in his statement. Disagree with it because we had held back some things in our cross-examination of him because we were going to save it to be in front of the jury.
So what ultimately happened to this guy?
So then we tried him again. He was in prison for 2.5 years or so during the appellate process, and because he'd received 144-year sentence or something like that.
Ooh.
And
That sounds like Indiana.
And so then they also, so we tried him again. By this point, the original conflict wasn't there in the St. Joe County Prosecutor's Office. So tried it a third time with one of the deputies from St. Joe County. And the jury again hung.
Oh my gosh.
And so we ultimately decided, based on all of that, that we couldn't go forward a fourth time with any realistic hope of getting a guilty verdict.
So he was freed.
Mm-hmm.
What do you think it was the main thing that the jury had a problem with? It must not have been the fingerprints.
There was another issue with a witness who saw him on a road. We even had a recreation done of the sunlight on August 25th of whatever year we were in, 2005 or 6, whatever. And the defense did that. I still, to this day, every time I pass a car, try to see, do I have a clear view of, could I identify the driver because of the glare that gets there. I think that was a problem because it was a split second. They came up to an intersection together and both cars were kind of moving depending on what the sun was doing. It just got into a very interesting way. We had
Boy, it really sounds like.
we had timing down to how much to drive from South Bend to Indianapolis before 31 was fixed. We had handwriting experts about the note that said white man, armored car. The defendant in this case was African American. So we had issues on cross-racial identification. There was a time issue with different witnesses as to what time the store opened and when people were coming in and out of it. It was very much a whodunit. If you Google Osco drugstore South Bend, I'm sure you will find stories about it.
So, I mean, what do you think was your strongest element in the case where you felt like you could convict?
Well, I thought the fingerprint on the push bar, crash bar, was pretty strong because it had been almost 6 months since he'd been an employee of the store, and that was a bar that all sorts of stuff came in, deliveries, people with gloves and pushing it, the door open, and it just seemed unlikely that a print could last that long. We also had issues about access to keys. The armored car schedule that picked up the money had changed, so there should have been more money. If you were going on the information you had back in March, there would have been a lot more money in the drawer on that Saturday morning. And and then we had the identification by the woman who was driving by. So
But you had to believe her. These days, everybody's got these stupid tinted windows. Sometimes I want to see, who is that driving next to me? And you can't tell.
But from the legal side on this, to try a case 3 times, I don't recommend it. It's really tough. And I know we just had one that hung for the second time, a child molesting case that we're still kind of looking at to see. The impact on the families is so great as they're getting ready in this situation when we had the families of 3 victims.
But on the other hand, I'm sure the victims, they said they wanted closure.
Oh,
so.
no question. They would have come back every year forever.
Is this his name?
Yep.
Okay. You can find this, the appeal anyway, on, how do you say that? Justia? I always want to say Justia. Justia. Every time there's an appeal in Indiana, or maybe everywhere, I don't know, it's Justia U.S. Law, and you just put it in and it pops up and it goes into more detail. It's almost like, well, it's not really court records, but it'll go into it. And
I just call it Justia.
Justia. I think it's because
Give it the English pronunciation.
my language training or Justia. But anyway, if you want to look it up, all I did was put in Osco drugstore murder and it popped up. So Osco drugstore murder, yeah, and you will see it. And then, of course, we have the tennis shoe here too with Steve Alpert, which I didn't realize that, but I don't travel that much in Indiana. Maybe I should start. So anyway, do we have any closing comments or do we have any rants? I do have a rant, but I haven't prepared it, so I'm going to hold off.
Well, I think double jeopardy is one of the key components of the American criminal justice system. It is certainly a right that provides closure for defendants. Mm-hmm. And I think it's an important civil liberties protection. It can be a little frustrating just from the standpoint of striking that balance of not so much accepting the fact that, okay, you lost, but if you do find new information, that it prohibits a prosecutor from going forward. And that's where I think it frustrates families because they want closure, they want something done, but if we go too quickly, we risk bringing a case that may not be as good. And particularly, I think in this day and age, a single eyewitness, you're saying, oh, so-and-so says they did it. Well, if that person is not real credible, you're going in and asking to put an awful lot of weight. And I've heard way too many times from juries about whether they hung or found him not guilty. A lot of times they'll say, after a hung jury, they'll say, well, we just needed more evidence. And it's the type of thing that, if we had the evidence, we would have presented it.
That's right.
We can't exactly go down to the evidence store and check out
But at the same time, like my right hand and I have noticed that sometimes you can go back and retool your evidence. So
there are times...
Emphasize certain things that maybe you didn't the first time around.
Well, and I think that's something that does happen after hung juries. Mm-hmm. Sometimes they are... This gets into a whole nother area, but a hung jury that's 11-1 may just be a person who doesn't want to sit in judgment on somebody, or for whatever reason doesn't feel like it was there.
Right.
I usually don't mind at all saying, okay, we'll try it again. But if you get into a more evenly balanced, I think you have, in fairness to everybody involved, the defendant as well as the victims, you have to look at the case and say, is this winnable? Or are we likely to run into a hung jury every time we do this because the facts and the evidence in this case are just ones that you can't necessarily find 12 people that will all agree with it.
12 people. That's right. All right, my right hand, you want to say anything?
Nope, I think that was a good discussion, and I want to thank Mike for the great explanation of double jeopardy.
I know, because you and I weren't quite prepared to do that. So anyway, all right. Well, in that case, want to refer you to all our podcasts. This is number 25. So congratulations, Mike. And we've had a really good time doing all of them. We've had some interesting discussions. It's obvious that Mike and I don't agree on everything. And then when my right hand's here, you can have 3 different opinions. So please go and see the articles that are on www.theprobablecause.com or our Facebook page. And you can also listen to these podcasts on Apple or Spotify. So for now, this is goodbye from The Probable Cause. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.
Worried when I crossed the Michigan line, a cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over. Charged me with possession after I rolled down the window. Now that's skunk. Indians a trick when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throw in the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should've known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey on my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C-shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated. This knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. Man. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild and hit her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable cause. When I was young, caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you
Whispers
cry.
and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause.